Hello, everyone. Thank you for joining us for Privacy Enforcement 2026 Regulators Focus and Compliance Priorities. My name is Matt Davis. I'll be your MC today, so to speak. I'm the marketing content lead at Osano. If you're not familiar with Osano, we're a data privacy solutions vendor. Our goal is to make sure that data privacy compliance is simple for businesses of all sizes. So whether that's consent management, subject rights management, et cetera, we try to make things easy and manageable. And as part of that mission, we're here to talk about all of the data privacy developments that have happened in the first half of 2026. We like to do these mid-year updates because a lot has happened. And well, I won't get into that. I'll hand it over to our main speakers for the day. Actually, before I do that, some quick housekeeping announcements. I just want to direct your attention to the chat widget at the right side of the screen. You'll see there's a chat window. I can see a couple of people have said hi already. Hello to you as well. There's a Q&A section, so if you have any questions that come up as we go through the content today, feel free to add them in there. There'll be about 15-ish minutes or so at the end for questions, and we'll answer them as we can. Now I'll hand it over to our speakers. Take it away, Ashley.
Awesome. Thanks, Matt. Welcome, everyone. Again, thanks for joining. My name is Ashley Fowler. I'm the Senior Privacy Program Manager here at Osano. I spend my days helping my own organization operationalize privacy compliance, but also ensuring that our product is in a position to help our customers do the same. With that, I'll pass it to Jodi for your introduction.
Hi, everyone. I'm Jodi Daniels, and I am a CEO and privacy consultant at Clover Advisors. We are a data privacy consulting firm. We are helping companies comply with the long list of privacy laws these days and really tackle all those operational to-dos to comply with privacy laws. So excited to be here today.
Yeah, Jodi, thanks for joining us. Really excited to have you here. We've worked kind of in the same realm, but I'm glad to actually get to do a webinar with you for once. So appreciate that. So just on the agenda, first, we're going to walk through significant developments in the U.S. privacy landscape. There's a lot going on globally. We know this, but we don't have 3 hours that we can spend with you. We only have one. So we're going to stick to the U.S. today. New enforcement actions, newly enacted laws, some bigger structural shifts. We'll get into some wiretap and VPPA litigation. That's moving fast. It's in its own world right now. And then we'll close by pulling it all together with some reoccurring themes that we see across these enforcement actions and what they actually mean for your program. Next slide. Just really quick, before we dive in, a word on what the content's based on. So Osano put together a State of U.S. Privacy Enforcement report. We analyzed every significant privacy enforcement actions from January 2025 through May of 2026 across comprehensive state laws, data broker laws, private litigations, and we pull out themes and practical steps for you all today. So today's webinar is sort of a mid-year update from that research focused specifically on what's happened since January of 2026. This full report, Matt, come in and correct me if I'm wrong, but will be available and can be given to everyone on this call along with the slides at the end. So next slide, we're going to actually do a quick poll for you all. So a poll is going to pop up. How would you describe your organization's privacy program right now? So take a second on that. I'm going to wait for some of that data to come in. I think it's probably going to shape a lot of what we talk about anyways. All right, looking good. Okay, I think we're feeling pretty good. Jodi, it looks like over half of the folks here are actively working to build or improve their program, which is great. And then we have a split between already having a mature program, which is awesome, and then a program in place, but rarely auditing. What's good about this presentation is I feel like we're going to have information that's going to be valuable to all of you, but certainly those that are actively working to build your program. We have a lot of good takeaways from what we're seeing from enforcement and how you can apply that to keep your company safe. So, all right, next slide. All right, so we're going to start with the landscape, new enforcement, new laws, structural shifts. Matt, if you want to go ahead and move to the next slide, great. This single slide is really the headline of the whole webinar. This is a lot that has happened in 6 months. I'm going to walk through the timeline. I'm going to resist the urge to dig into any one of these in particulars because we're going to come back to a lot of them on the detail. Jodi's going to hit a lot on the enforcement actions. But let's just quickly go through the timeline here. In January, 3 big things. Kentucky's Attorney General filed the first ever enforcement action under the state's privacy law. That was filed just 8 days after the law took effect, which is kind of wild. California's updated CPPA regulations took effect. We got new data broker deletion platform and drop that launched. And the Supreme Court is going to weigh in on the Video Privacy Protection Act, which I'll get into a little bit later. In February, big fine against Disney. Not going to steal Jodi's thunder on that. She's going to talk about that a little bit later. In March, we saw 2 actions within the CPPA, the California Privacy Protection Agency, on play on sports. And Ford, also in March, Oklahoma enacting a privacy law. In April, Alabama enacted a privacy law. In May, we got a big one for enforcement-wise, General Motors and OnStar at $12.75 million, an all-time record for CPPA or CCPA. They love setting records over there. First ever data minimization or highlighted data minimization case. I'll let Jodi talk about that. Texas sued Netflix. Oh, and also Louisiana enacted its privacy law. Just recently in June, Vermont enacted its privacy law, bringing it to the 23rd state. So a lot happened. And the pattern I think that I would want everybody to take away from this is we still have our patchwork of privacy laws. It continues to grow. We do have a federal bill that's being introduced. I know everyone on this call, no one is putting all of their eggs into that basket. Another takeaway here is enforcement isn't theoretical. It hasn't been, frankly, for several years. The dollar figures are high. They're climbing. The map of legislation keeps expanding. But we'll break down kind of what all of these means and what you can do as a company to protect yourself. All right, so Matt, let's look at the newly enacted state laws. Since January, 4 states have enacted comprehensive privacy laws: Oklahoma, Alabama, Louisiana, and Vermont. Vermont was mid-June. That brings us to 23 total states. And for some context on how crazy this is, we waited almost 2 years, I think, between the 19th and the 20th state. And here we saw 4 states added within like a single like springtime area, which is pretty crazy. The good news is that for most of this, the template's pretty familiar, right? We're seeing Virginia, we're seeing Connecticut. There's nothing that we're seeing that is super outlandish with any of these laws. So if you're in a compliant state, as is with the states, pun intended, you're probably in a pretty good spot. But we'll talk about some nuances here. Oklahoma, very standard, effective January 2027. Alabama, the one thing I want to flag about Alabama is its threshold. So we've seen the 25,000 residents threshold. We've also seen a percentage of revenue from data sales. What makes Alabama a little unique is it's got the 25,000 low and or another 25% of revenue data sales. So the or is important here because both the 25,000 residents and the 25,000% is pretty low, and it's either one of those. So it does kind of bring in a lot of maybe more mid-sized businesses, but again, nothing within the law itself is screaming out anything crazy. So if you're kind of within those other laws being swept in, hopefully wouldn't impact you too much. It also carries a kind of significant fine. You can see just on this chart here, $50,000, $15,000 per penalty is relatively high. So Alabama takes effect in May of 2027. Louisiana is notable for keeping the 30-day cure period. Most newer states have actually dropped these, but that is due to sunset in 2027. And then I would say Vermont, if I had to pick the most protective, it would be Vermont. Out of the 4, honors the universal opt-out signals, has strong consumer health provisions, and that takes effect in 2028. Quick contrast, you can see on this chart here, Oklahoma and Alabama do not require honoring universal opt-out signals. Louisiana and Vermont do. This distinction, it matters. It's a great segue into some things that we'll talk about later. One thing I just want to note really quick that we don't have time to get into even for the states is please keep on your radar the amendments of existing laws. We've got Connecticut, who has some amendments coming out effective tomorrow. Oregon has some taking effect. I think Delaware's House just passed some to keep an eye on. Colorado and Montana did some earlier towards the end of last year. So they all are moving in the same general direction. We're seeing lower thresholds, expanded protection of minors, new sensitive data categories, broader opt-out and profiling rights. So I just want you all to take away here. Yes, we see that new laws are coming, but unfortunately, existing state laws are also moving targets that we all need to keep an eye on. So with that, that's a recap of what we've been seeing so far. I'm going to pass it over to Jodi to dig in on some of this enforcement.
Yes. And if I could, I just wanted to add a little bit to what you just shared. So I think one of the interesting nuances in Alabama is if you're a nonprofit, you also might be swept in. There's some unique provisions. So any nonprofits listening, you really got to look by state to figure out what's happening. And I just wanted to add to the amendment part where it's very much like whack-a-mole with amendments. And I think we're not done on amendments. We're going to see more and more, especially you mentioned Vermont. I think other states are going to look at some of the provisions in Vermont and say, oh, I like that one, and I'm going to do this. And that's what's happening across the board. If you're listening and you're B2B, maybe you're only having to deal with California. California is also notorious for amendments, and I can't speak for them. I don't know what they're thinking. But if I were a state and I have all these other states that are here, I'm going to look across the horizon, and that's how we start to have amendment city. So stay tuned, and amendments are not. We're not done with amendments. So, all right. I get the fun of talking about some of the different enforcement actions. And I think what you're going to find is much like the privacy laws, there are some common themes that you're going to feel from each of these different enforcement actions. When we think about the Ford Motor Company, part of the challenge here was they were asking consumers to verify email before processing an opt-out of sale and share. As a reminder for processing opt-out of sale and share, you don't verify for opt-out of sale and share under California. That is one, I just get that right. For deletion and access and correction, you get to verify me. So you don't want to also continue to sell and share the data if I've opted out. So when someone says opt me out of that information, you want to ensure that it is actually processing. This is a really common find, especially if your opt-out of sale and share is related to ad technologies. If you have that turned off, or so you think, you have to test it and really ensure that your consent management platform is actually working properly. And think about any downstream vendors that you might have sold that data to, and ensure that you are breaking that chain to, the opt-out part has been broken, but you need to be able to communicate downstream for processing that opt-out of sale and share. And Ashley, you were talking about global privacy control and which states have it and which states don't. And it's kind of whack-a-mole of which ones for all of these different things. And I find a lot of companies are choosing, especially we're at 23 signed states, they're just taking an all across the board approach. For global privacy control, this is another one that you need to actually test to make sure it's really working. Because if I have it on and then doesn't work, that doesn't really work. So you have to make sure they're actually working. And with Play on Sports, this is going to be fairly similar types of things where there were opt-outs that weren't functioning properly, where you weren't necessarily providing the opt-out of sale and share. The global privacy control in this situation wasn't honored. And again, if you end up, so just as a sidebar, for the companies listening who choose not to go with it all across the board and you choose to go state by state, make sure that when you choose state by state, you have the right states in play. One of the benefits of going across the board is it's going to be a lot easier to just test. It's working, it's not working, it's on, it's not on. If you start going state by state, that just makes your internal operational process a little bit harder. But the Play on Sports piece, this was also the first case that addressed children's data. One of the things you're going to notice, especially right now, we're sort of in these early-ish days, even though we are a couple years in for the Cal privacy ones, is some are going to be opt-out of sale. Some are going to be children's data. Not covered here today, but Tractor Supply was one that focused on employee data. That was one of the first ones to tackle employee data. And you're going to, I think, kind of continue to see that theme across the board. So making sure cookie banners are actually working. You're managing whichever type of sensitive data. Maybe it's children, maybe it's health. Making sure you have your global privacy control. Play on Sports did not have that functioning properly, and privacy notice deficiencies as well. So what was actually being processed and what was being disclosed were not in alignment. Do I get to? Here we go. Perfect. Okay. So our friends over at the Walt Disney Company, I do love the Walt Disney Company. I might drink out of my Walt Disney Mickey Mouse and Minnie Mouse mugs all the time. In this particular situation, this really brought up the challenge of cross-device and the ability for opt-out. So the theme being opt-out, but again, they're kind of being particular on an area which was around cross-device and also sort of affiliates. So here, there's Disney Plus, Hulu, ESPN. They had all these streaming services, and an individual user needed to go to each one of those to process their opt-out. And the philosophy was, nope, it should be across the board, one request to all of those services. So the other piece is around cross-device. If I have a mobile and I have a desktop and I am Jodi, I shouldn't have to go to mobile and make my opt-out and go to device and make my opt-out. It should be once and it works across the board. This is a technical setup. And for anyone listening, if you have a consent management platform, you want to ensure that whomever has set that up, your privacy team is working in conjunction with your marketing, potentially product team too, to understand the actual pixels and activities taking place to identify, do you have any cross-device targeting happening? You might not. If you do, then you need to ensure that the opt-out is working the way Cal Privacy is looking for it, which is this single opt-out carrying across all the way downstream. How do you do that? You have to identify what are the tools that are actually happening and be able to tie those pieces together. There is some engineering activity that might be required to make this happen. Here is the cross-functional in effect right here. This is not a privacy person can do it alone. This is not whoever's been anointed and assigned owner of a CMP to do it alone. You have to understand what's actually happening on the site and on the app to be able to bring those two pieces together. If you have multiple brands where that information is kind of like the situation where you had a Disney Plus, a Hulu, and ESPN, all streaming services, you might want to look at what your process is like as well to be able to make a singular approach versus having a user have to go to each individual one. And then we have General Motors OnStar. This has shown up for California, but it also has appeared in other states. This is where location information is being collected, not just for the OnStar services, but to also be able to be collected. It was shared, it was sold with data brokers and consumer reporting entities. That was not, it was allegedly not provided with adequate notice and consent to the individual. So I might think OnStar is okay. I have no idea what's actually happening behind the scenes. Connected vehicle data is very important. If any of you are in the automotive space, you'll want to pay attention to this. If any of you think, oh, I'm not in the automotive space, I can tune out. No, don't do that. So the theme here is around notice and consent. If you are processing information for purpose A, you have to ensure you've provided the right notice and, where applicable, consent. Maybe you need consent because you're processing children's data or sensitive data like health or the long list of unique definitions. Got to go state by state for your sensitive data. So look to see, might you be processing any of that? And you too might need consent. So you'll want to ensure you have the appropriate notice, the appropriate consent for purpose A. If you then want to have it used for purpose B, you have to have a separate evaluation and determine what else might need to happen. So while this was very focused on a connected car situation, location information, it really, I want to extrapolate what are the learnings that everyone here can apply. And it's going to be data minimization, only collect what you really need. Make sure you have consent for what's deemed sensitive data, look by state or region. Ensure you have the appropriate notice in place, review your data broker relationships, and of course, make sure you have clear controls for the consumer. All right, so now we have Texas, where there's multiple ones. We're not going to necessarily go through all of them. As Ashley said, we have a lot of content to review over here. So we have deceptive practices. We have Netflix. And then we have, kind of TV and how they're smart TVs and how they're sharing data. The theme here, again, is very similar to the OnStar suit, which is a consumer thinks they're getting service A, and behind the scenes, information is getting collected, packaged, and sold to somebody else that was not what the user had intended. If I think that I'm watching these 5 shows and Netflix is managing those 5 shows so that it can suggest 5 new shows, that's different than packaging up that information and sharing it with data brokers. If I have a smart TV, I think it's smart. I can talk to it. I can connect it to devices. It's smart. It's beneficial to me, not so much that it's going to package that information yet again and sell it to somebody else. So again, the very, very common theme here is actually almost back to basics, which is do what you say and say what you do. And now we have some complicated privacy laws. You actually have to evaluate, can I even do what it is you want to do? If you can, you have to be able to communicate, identify if there's going to be any consent that needs to happen. This is also, in my opinion, the blend you have of privacy meets consumer protection laws at the state level, and of course, our friends at the FTC. It is all about consumer. Is it unfair and deceptive? Did I expect what was going to happen? Privacy notices are our way of telling you that's what's going to happen with your personal information. This is personal information. This is where these two pieces start blending together. And it's really important to not do that, to be clear, to be fair and clear. And then Ashley, you had covered some of the, cure periods under some of the other laws. So here's kind of a reminder that Oregon's cure period expired in January. Minnesota also expired, and they sent some nice warning letters to a variety of companies saying, we're going to be questioning what it is that you're doing. And in Kentucky, they filed an enforcement against Character AI, where many teens, especially minors and teens, were using these apps. There was no age verification, no parental consent, and you just need to go to Google and look at the headlines where there are some unfortunate situations with minors and teens using this app. And so therefore, there's a lot of concern around the type of data, the type of product design that's being used, and what they're doing with that information. So again, if any of your products or services might be used or knowingly are used by children and teens, the scope of children and teen is very different these days, and be sure to identify which law might be in scope for you. That was my whirlwind. Okay, continuing on rather to data brokers and children's data. Drop deadline. Now, Ashley, I think actually you get to have all the fun talking about drop, or am I talking about drop? Kindly remind me. I get to have all the fun. You get to participate. Amazing. Okay. So tomorrow, people, is a very, very big day, July 1st, which is when public disclosures are required. And for those who forget what drop is the system that California has in place from the California Delete Act. So there's 2 sides to this. Data brokers, which is a really broad definition. You can see it up here on the screen. And if you really want to read, you can go to 1798.99.80C to read all about it. But data broker is very wide, and it really does capture many more companies than maybe traditionally people thought a data broker would. That's one side. All data brokers have to register. And then consumers get to register. So consumers in California get to go and register. And effective August 1st, the two must honor each other. So from January 1st all the way till, always, but right now they're pooling all the California residents who want to be able to delete their information from a data broker. It is over a couple 100,000 people. At last count, which was probably earlier this Monday, it was over 300,000. It's gaining significant traction. This is only going to keep growing. They've barely advertised as well. And so once it hits, I think we're going to see these numbers climb really significantly. And then the data brokers, again, I said they have to register. And starting August 1st, all data brokers have to honor all of these individual requests. and have their data removed from their systems. If you are listening and you are not a data broker and think, whew, I don't have to worry, your sales and marketing teams might be negatively impacted if they buy data from data brokers. Over time, those pools of information are going to shrink, and they might start to see the impact. And the reason is because of the California Delete Act and the drop deadlines approaching. Note, we have a couple other states that passed pretty similar type laws, Connecticut and a couple others. They're not here yet, but they're coming. So this is the future of where we're moving. And if you are listening and you're like, I don't know if we're a data broker, this is a really good time to chat with your privacy and your legal teams to identify, might you be? It is a very broad definition. And children's privacy. So we have Federal Trade Commission with a verdict over Disney for $10 million. This is really similar to the California one, where it is deceptive practices. Here, one of the really big ones was video content that was on YouTube, and it was not appropriately labeled as children's content. And then we also have the Kentucky one we just talked about with character AI, and we have the play on sports. So we have a federal, we have 2 states that are both addressing children's and teens. Children's and teens information is complicated. We have where you have app stores that are going to start receiving signals in a couple different states. Then you have the age appropriate design code in a couple states. Then you have states that have comprehensive privacy laws, and children are a defined term underneath those states. If you process information, and I keep mentioning teens because that's actually where a lot of these laws are trying to expand, you really want to be mindful of what is happening. And everyone always asks, it's going to be a federal children's law. I don't know, but we have what we have today, and we have to make sure that we're addressing this. And again, many of them are capturing that teen market. Are you a retailer? Are you in the food business? Are you a software company, a gaming company, a social company? You really want to, an ed tech company, you want to really be thoughtful to children's privacy. This tends to be a bipartisan issue. Notice, choice, potentially consent, thinking first before you're doing something, not being deceptive, not having a deceptive product design. All of those things are very, very critical and a non-negotiable when it comes to children's and teens data. Ashley, what did I leave out that you would like to add?
Nothing. I think you did really well there. I actually will add a little bit more when I go into some of our themes later, but for now, I think we're good. But I'll definitely be
perfect
circling back. So thank you, Jodi. I appreciate that. We're gonna move on. So Jodi just talked about a lot of regulatory enforcement from regulators, but let's move to plaintiff's bar, right? Plaintiff's bars, because I think Jodi would agree some of the biggest privacy exposure we're seeing in 2026 isn't actually coming from state agencies at all. It's coming from private lawsuits. So if you want to move to the next slide, Matt. If you haven't heard of SIPA, I'm going to say it's SIPA. You can say it's SIPA. You can say it's CIPA. You can say whatever you want. You're not wrong. But if you haven't heard of it, it's the California Invasion of Privacy Act. I will say, if you haven't heard of it, consider yourself lucky. It is impacting a lot of companies right now. Just to level set for anyone that's unfamiliar with it, it's a wiretapping law from the 1960s. It's written for telephones. It's become one of the most actively litigated privacy laws in the country right now. How it works in practice is plaintiff firms or very determined individuals run automated scans on websites looking for third-party tracking technology that's firing without consent or pre-consent. So we're thinking pixel, session replays, cookies, chatbots. They can go onto your website, they run a scan, they can easily see it. I can go onto any one of your websites now and see what's firing as soon as I land there. If they see these third-party trackers are firing pre-consent, you'll likely get a demand letter. I will tell you from just what I've been hearing from privacy attorneys, et cetera, these inquiries are arriving rapidly, weekly basis. And the reason why it's so attractive is just what I said earlier. It's opportunity, right? It's very easy to see what a company's website is doing pre and post consent. Also, it's the math, right? Every statutory damage here is $5,000 per violation. Every website visit is a separate violation, so it can really get up to scale really quickly. And then also SIPA it requires all party. That's what makes this so effective in the first place. Without staying on that too long, I do just want to say very briefly that a lot of the enforcement actions Jodi was talking about, as you notice, we do tend to see larger companies getting hit. Not saying that you're off the limits if you're a mid-sized business or small business, but we generally see these big enforcements, and I hear everybody say all the time, I don't think they're going to be coming after me. SIPA and these wiretapping laws have no discretion. These plaintiffs' attorneys and these individuals are going after anybody and everybody. It does not matter because there is no threshold or limit there. So just want to kind of put that caveat in there before I keep going. The one thing that we're seeing with these demand letters, that on top of it, we're starting to see them bundled, and we're seeing other I guess you would say regulatory type behavior and other laws put into these demand letters. What we're seeing right now is the ECPA, the federal wiretapping law. On paper, seems weird that you would add that because it's one party, which means like you as the website operator, if you're consenting to installing the tracking technology, that's a reasonable defense. The twist here and why ECPA is being added is their crime tort exception. So it's not really the interception itself, is if the interception is being carried out for the purpose of committing a tortious act. So one party consent doesn't save you here. And the reason why this is why we're seeing this is courts have accepted a few things that would apply as a tortious act: HIPAA violations, invasion of privacy claims, and the most recent one that I wanted to hit on is inaccuracies within your own privacy policy. Jodi said it best: do what you say you're going to do. If your privacy policy says you're doing one thing with your website tracking technology and your tags, and your website's doing another, that mismatch itself is the tort. Additionally, ECPA is double the violation. So you're looking at 10,000 per violation. So it's just a way to sort of add on the damages there. Another piece that I'm starting to see, Jodi, I'm not sure if you've heard much about this, just something I wanted to mention, but we're hearing about the CDAFA, which is the California Computer Fraud Law, and it's kind of taking an entirely different angle. Again, not focusing on the interception itself, but it's focusing on the unauthorized access to a device. So the argument is that embedding third-party trackers and scripts is causing a visitor's device to be accessed without consent. So that's kind of an angle people are taking. I'm not seeing this take off super fast. It's just something that's been mentioned and something that we want to keep an eye on. But as you can see, anywhere people can grab right now and any loopholes they can find, especially when it comes to what you're doing on your website, they're being found. Also, the CDAFA includes attorneys' fees provision, which makes that obviously a little bit attractive for plaintiffs' firms. So what you end up having is this demand letter that's packaged with a lot of different laws, and it's deliberate. It multiplies the damage exposure, it raises settlement leverage, and it makes early dismissal much harder. And when I talk about settlement leverage, and Jodi, I'm sure you've probably had clients run into this, no matter what, if you get a demand letter, it's going to cost you, whether that's time to reach out to an outside counsel, whether that's time that your business is going to have to put into figuring out remediation. Did we do anything wrong? And a lot of these firms are kind of using on the basis that you're going to settle because the cost of going to court is maybe too much. But I'm really honing in on these because no matter what angle you look at it, if you get a demand letter, your business is going to spend money on it in one way or another, whether you've done anything malicious or not. So another thing that I wanted to flag, you'll see on the slide that, and I feel like Jodi, I feel like you kind of got the normal news. I'm getting like the bearer of bad news here. But another thing that we're maybe starting to notice that I don't want you to lose sleep over, but I really wanted to bring this up is the plus CCPA on the horizon. So really quick context, CCPA has historically been off the table for any of this because private pixel litigation, the only private right of action sort of stipulation that CCPA has is for data breaches. So hacker gets in, data gets stolen. Also CCPA is a historically opt-out regime. You don't necessarily have to have consent before, you just have to make sure there's a way to get it and give the user the choice. But there was a case in 2025 going back on that breach part, the private settlement, Shaw versus Capital One, and it sort of cracked the door a little bit for that data breach. piece. And so a court allowed, so this, just to level set, this is still open. The lowest level of being able to get through somewhere is not having it dismissed. So, but a court allowed a CCPA claim to proceed without a traditional breach on the theory that running non-consensual trackers could be a failure to maintain reasonable security practices. Again, that said, surviving a motion to dismiss is a very low bar. This case is still active. This is narrow. This is not something we're seeing a lot of in any of these demand letters, but it's just something that we want to keep an eye on. Again, watch it. Don't lose sleep over it. However, the SIPA, the ECPA, your standard wiretapping, this is a very, very real concern for all size companies. So if not already, you should be strongly considering having an opt-in regime on your websites that prevent these third-party trackers from firing pre-consent, because from what we've seen, that's really the only defense that companies have against these types of wiretapping laws. Awesome. Okay, next slide, Matt. But wait, there's more. The other big litigation story, if you haven't heard, the Video Privacy Protection Act, or VPPA, again, consider yourself lucky. If you haven't heard about it, it means it's not impacting you. Another old law that came about from a reporter publishing a judge who was up for Supreme Court nomination. Reporter came out with this judge's video rental history. So like SIPA, it's been repurposed to the modern web, and it's driven thousands of pixel-based class actions. And so what's new and why I wanted to talk about this today is there's a case, Salazar versus Paramount Global, that the Supreme Court has agreed to hear. And the question that they're going to be taking up is kind of narrow, but it's really consequential. The VPPA protects a consumer, and the court is going to decide what that word means. Does this cover someone who subscribes, say, to like a newsletter or a free email or a newsletter email from a company that happens to host some videos on their website? Or is a consumer going to be someone who subscribes to an actual like audio visual service itself? And that's a major distinction. It sounds technical, but it matters because right now the courts are split on what they define as a consumer. And so with a lot of these types of wiretapping and then going to VPPA, it kind of matters where you get sued, right? As to what, like Jodi and I aren't going to be able to tell you today, if you're doing XYZ, you're safe. If you're not, like, everything is up in the air right now. Whoever is judging the case is going to make the decision up in the air. But where that case falls, they should start contemplating in the fall term. We should have a decision in 2027. If the consumer stays broad, you're going to see a lot of companies that traditionally we wouldn't have thought would be in this. If you're hosting videos on your websites and you've got some sort of tracking on it, to be able to see that, this ruling could impact you. But I don't have any insight on which direction that's going to go. Truly, if I did, I promise I would share it, but I don't. But definitely something we want to keep an eye on. All right, Matt, next slide. All right, so I feel like I've delivered a lot of bad stuff. So the good news is let's synthesize this. Let's look at these enforcement actions, and let's talk about patterns and themes and steps that we can use here. Matt, you can go ahead and go to the next slide. So one. This is Jodi. This is where I'm going to tap into a lot of what you said, right? We're going to look into these enforcement actions and see where we think these main themes are and where the problems can be solved. Opt-out mechanism failure is the big one. There's a button, there's a toggle, but the technology doesn't do what it's supposed to be doing. The signal didn't work. The tracker's fired anyways. We learned that lesson from the enforcement actions that Jodi just talked about. So make sure that's something that you're looking at. Universal opt-out or GPC noncompliance. It is the universal opt-out, I think, is now legally required in over half the states. And I think it was 2025. It was just last year, Jodi, that you saw that first coordination of multi-state enforcement sweep on GPC specifically. So it's a big deal, something we want to watch for. Dark patterns and consent asymmetry. We've been hearing this for many years now. This is not new, but it's something that we are still seeing active enforcement on. Rule of thumb, opting out should be just as easy as opting in. It's codified now in California, effective January 1st. PlayOn got in trouble for it. The days of being able to kind of gate or trick your consumer into accepting, it's just so easy for regulators to call out, and something that you need to be aware of. And then vendor and contract failures. We are noticing regulators are reading contracts. They're not just looking at contracts as exist. They're reading it. If there's We're starting to see the vague language, what we talked about with any business purpose. That's not going to work for CCPA's purpose limitation and some of these other things. Ford's a good example of that, right? You need to be explicit in your vendor contracts under the assumption that a regulator will read them. And that's a very real thing that we're seeing. Well, let's go to the next 4. All right, Jodi talked about it. Children's data, sensitive data. Generally, this is a bipartisan issue. One of the key misconceptions I just wanted to point out is for CCPA, affirmative authorization for teens is 13 to 16, not just kids under 13. So we see this across multiple cases. We're going to continue to see children's and sensitive data be a primary marker in some of the themes of enforcement that we're seeing. Privacy notice deficiencies, not only did Jodi talk about it, I talked about it also with some of the wiretapping ECPA stuff. We're seeing this as a lot of secondary violation. You need to make sure your notices are showing where they're supposed to be. They don't need to be hidden, but also that your notices are saying what you're doing is actually what you're doing, right? They need to be accurate. Purpose limitation, data minimization. Again, Jodi, I told you I was going to come back to everything, Jodi. This is something that we've talked about. Data collected for one purpose, quietly being repurposed for another. It's not compliant, right? And so we saw that. I think the biggest one was probably GM. And then this one, number 8, the non-cooperation aggravated outcomes. We've seen over and over again that the difference between like a cure letter or a 6-figure penalty isn't necessarily the severity of the violation. It's a lot of times how a company responds once a regulator comes knocking. And with cure periods now expired in most states, some never had them. The response window is shrinking. So how you engage is increasingly becoming important. So that's a pattern. Details, full citations of the report. Again, we're going to get that to you all. I think right now, Matt, let's go to our final poll. And caveat here, we can't fit this many answers on our typical poll. So if you're okay with it, you'll lose anonymity. But if you could please put in the chat one or more of these things that you all are more concerned with. And honestly, another cool thing about, as a privacy person, I'm like, oh, it's not anonymous, but it is actually cool to see what other people are struggling with and maybe even make those connections afterwards. So I'm going to pull this and just keep an eye on this really quick. Let's see. Mm-hmm. Lots of 7s. 4s, yep. Mechanisms, yep. Yeah, so I don't know about you, Jodi, but I'm seeing a lot of 7s here, which is purpose limitation, data minimization. I think one of the biggest headaches, not only I've had in a privacy professional in my career is, and maybe that's what you all are getting at here, is not knowing all the data that your company is ingesting and what's being done with it, right? It's not that you're knowingly doing things maliciously and using it for other purposes. I think what I'm hearing with number 7 is a lot of you probably just don't know, and that unknowing makes you very uncomfortable, and that's fair, right? How do you know if you're being minimalist with your data if you don't quite have an eye on the sprawl? And so I think that's something that makes a lot of sense and keeps a lot of privacy professionals up at night. So thank you all for answering that poll. Matt, if you want to move forward here. So what I'll say about this is what are we going to do with this, right? We have the 7 highest impact actions in order that we feel are the current risk exposure, or I feel. Jodi, feel free to, if you want to switch these numbers around based on what you've seen, we can talk about it. But to be clear, this is just our interpretation. Please take it with a grain of salt. Every company, you're going to have different priorities and a risk posture in general. So to reiterate, very high risk opt-out and GPC implementation. To consent interface design, again, symmetry. Opt-out steps should not be any harder than opt-in steps. Identity verification is not required and not even really allowed anymore for a lot of the opt-out flow requests. So make sure that's being gated as properly as well. Number 3, and what you all were most, I think 4, I think I saw a few people worried about this, but is third-party governance, right? Auditing the contractual language, knowing what third parties are doing with your data, being very prescriptive in the contracts, and making sure they're not just a checkbox. Number 4, children's and sensitive data. We've talked about it. If you are a business that knowingly has this data coming through, there's obviously a lot more provisions on you that you need to be aware of and need to be considering. Number 5, test your consumer workflows, right? So when we're talking about subject rights requests, I felt like, Jodi, I don't know about you, but I felt like they were I wasn't seeing a lot of enforcement action on them for a while. It just seemed like maybe companies were either getting the flow or regulators are focused on something else. And then bam, we see that it was a part of one of the most recent enforcement actions. We're back to making sure that your subject rights flow requests are easy. They're monitored. They're actually being tested, and remove verification where it's not necessary. Privacy notice accuracy. I'm not going to belabor this. We've talked about it. Make sure you're auditing your privacy policy. If it hasn't been updated in like 3 years, it's very likely that you're going to be a target. Those are things that regulators look at. They looked at your dated version. So make sure that it's up to date with what your company is actually doing and up to date with what these states require in your privacy policy. And then number 7, back to planning for regulatory response. I did see many people a little bit concerned with regulatory response. That's a hard one, right? You're trying to build a program just to make sure that your company is compliant. And you also kind of have to build this like response team around that, which is a difficult thing, but it is something that can be very, very beneficial. So don't leave it as the last thing that you do. Jodi, anything that I've touched on before we kind of wrap this up into Q&A that you would like to go over?
I would say I didn't see very many people talk about number 3, established vendor and third-party governance, and maybe not as many privacy policies. And I just wanted to echo. So CCPA says at a minimum, you need to update that privacy policy at least once a year. So friendly reminder, it is a massive hint to anyone when you go to the site and it's not within the year. But in terms of the vendor and third-party governance, almost all these states and globally require some form of contracts. And you even mentioned, right, regulators are looking at the actual contract. And to get a lot of the cookie governance pieces right and to match to privacy policies and to know who's collecting data on your site and to be able to manage the opt-out properly and privacy rights, you really have to have that vendor and third-party governance in place. So I just wanted to remind everyone it's not as outward facing. And I see a lot of people focused on the outward facing pieces, which makes sense. At the same time, getting that vendor and third-party governance is essential.
All right. Matt, I think we're going into Q&A.
Yes. Thank you, Ashley and Jodi. Super helpful, super informative. And yeah, now we're opening it up for Q&A. So some folks have already added questions in. If something has occurred to you and you haven't gotten yours in yet, you'll notice that there is a little Q&A tab at the top of the chat widget there on the right side of your screen. I think it's the right side. And you can add your questions there and we'll get to them as much as we are able. So I wanted to kick things off with a question that I saw come up a couple of times, actually. So one of these is about how far back these enforcement agencies and AGs are looking when calculating violation counts and penalty exposure. And then a related question was whether or not they can count violations that happened before the law came into effect.
Ashley, do you have some thoughts on that one?
Yeah, I mean, I could start, Jodi. I mean, I'm sure you've had a few as well. I think, what was the one? Was it Play On? Where they just, I can't remember. Or was it Ford? Where they went back. I think they even went back. What was interesting to me about this one, Jodi, and I'll let you probably be a little bit more specific in what you're saying. There was one of them where they actually, I think the company had noticed something was wrong before they got caught and updated it, but the regulator still went back from that period when they were doing something wrong, and it might have lessened their violation or with their penalty. But I mean, I think we've seen them, I think, what is it, like a year is what we've seen, like, they go back, but I don't know if there's been like a definitive trend that you've seen, Jodi.
I don't think there's a specific trend. I think it's a little bit of a case by case and a state by state. So I know that's not the most black and white answer. I think, unfortunately, that one's a bit gray.
Yeah, I think it was play on that you're talking about. And yeah, it's kind of up to the AG in question, I suppose. Okay, another question we had here. So one attendee has been seeing privacy policies state that they don't recognize the global privacy control. Is that compliant? Is that okay? Should they be doing that?
I love this question. I've been excited to answer this question. So if it's okay, Ashley, I'm going to take this one. So there's global privacy control is the modern version of what used to be called sort of industry-wide as do not track. And there's an existing law on the books in California. It's really old. It's AB 370. Why do I know that? Because it was one of the first laws that I had when I moved into privacy. And it's really old. And it is still here, which requires companies to say, do you honor do not track, which has its own specific definition, which is not exactly the same as global privacy control. So to the person asking, my hunch is what you're seeing are the privacy policies actually say we do not honor the do not track signal, because that is actually a different signal than global privacy control. Companies absolutely should be saying they do honor global privacy control. Here's what you do, and here's how you can manage all your cookie settings. And you actually might also say you do not honor do not track, because it's this really old requirement under this old California law that is still here.
Nothing more on that one, Jodi. Thank you.
Yeah.
Okay.
It's one of those strange things I'll never forget.
And not only do companies have to honor global privacy control, I think they even now, under the California amendments, have to show a little signal saying, hey, we got your request and we're honoring that. So
that is right. And your CMP should be able to do that for you. That's not something that companies should have to go and figure out how to engineer out. Now, I will say to any of the companies here whose companies decided they wanted to build their own, this is one of those updates that you would have to make. And there are some companies out there that wanted to go and build their own CMP. And as these laws continue to update and have amendments, they're going to keep making these tweaks. And that would be on your company to have to add that. But if you're using a traditional commercial CMP, it should be built in. That's the benefit of using platforms like this.
Absolutely. So I wanted to ask this question from an attendee. I think there's a lot going on legislatively, so I don't expect Jodi and Ashley for you to know perfectly what the status of every law is, but is there anything that you're tracking? Any like proposals that are in the works? This person named specifically privacy or AI laws. Anything that you're kind of looking on the horizon that aren't enacted yet?
Jodi, I think Illinois might be on the maybe the thinking about comprehensive law, and then feel free to jump off me here. But as far as AI laws, I think the biggest news right now is kind of Colorado having to completely flip it because it was the first one, and just like anything else, when you do the first one, you start seeing what other people are doing. You're like, ooh, let me change that. But I do think we've had Jodi. The biggest thing I'm seeing sort of in the AI realm is AI chatbot laws. Seeing a lot of AI chatbot laws on the horizon. But yeah, I think anything is kind of up in the air right now. I haven't really seen anything that has me really shaking in my boots, is to use a Texas term. But Jodi, I don't know if you have any more.
There are. So let me first address some of the privacy pieces. Pennsylvania and Massachusetts are still hanging out there, and depending on who you ask, they have strong potential movement to keep going forward. There are some that you might see. So Delaware is waiting for signature. We will see if and when that happens. New Jersey, I think, also has some potential activity that is out there. And from a privacy point of view, that might kind of wrap us up for the legislative season a bit. And then from an AI perspective, definitely chatbots, but there's also a lot from kind of the way AI laws tend to be. There's some that are comprehensive, like Colorado, but the majority of them at a state level tend to tackle particular things: chatbot, employment. I just heard of a really particular one in Erie County for biometric That's a privacy one, I guess, not an AI one. But if you have people in Erie County, it's a county privacy law now, but you're seeing really specific ones. Mental health has been passed in different parts of the country. So there's a lot when it comes to AI. What I would encourage people is to identify who, maybe it's you who needs to follow these laws. IAPP has a variety of AI databases. Pick your favorite law firm. They're tracking it as well. There's a variety of resources out there to help you track on the AI side. Or if you have an internal privacy or legal team, ask how you can be copied on those. There's dozens. I mean, it's like every day there's a new one continuously getting introduced. And on the national level, there are a multitude of new AI laws also getting introduced all the time. Will they make it? Probably not all of them, but they are constantly getting introduced. AI just tends to be really niche: chatbot, employment, financial, mental health, pick your topic.
Okay. So we have a question here. I'm gonna tweak it slightly, but we were asked, are there legal ways to mitigate lawsuits related to vendors not honoring the rules we set on our main site? Now, we can't give legal advice, obviously, so I'm going to broaden this out. Is there any way to mitigate the risk from vendors that comes about from them not, adhering to the agreements that you have in place?
I have thoughts, Jodi. Maybe they're the same, but
Go ahead.
Free to jump on. I just immediately think of two things: contractual and auditing your website. Like we just talked about with contracts, it's not just about a checkbox. If you find yourself in a situation where the contract is really tightened up as to what your vendor is and is not allowed to do, and they still don't do those things, contracts are there for legal liability, right? The second part of that is the way to not ever get in that situation really is to be auditing your website. Whether it's kind of a funny area because Jodi can attest to this, who actually is responsible for website compliance vastly varies across companies, right? It could be the marketing team, it could be the privacy team, it could be the technical team. Having an audit and having a very keen eye on what's dropping on your site at any given time is in my mind actually better than any other mitigation. I know we have, of course, the Osano solution is consistently showing you what's new and popping in on your website for you to be able to look at and deviate. But I think those to me are the pop out as the most important for mitigation. But Jodi, I didn't know if you had anything.
I would add, just to a broader vendor context, diligence is your friend. And in those contracts, you often might have audit provisions, depending on the kind of vendor you might need to exercise that. Just in general is, if it's a brand new vendor, there should be a vendor review of all different kinds of privacy, security, and potentially AI related questions. If it's in motion for a long time, how do you go back and evaluate those vendors? I typically see some type of rotation to go back and have someone evaluate, who are you, what's changed, how are we still using you? And diligence and asking questions and poking holes is one of those ways that shows you didn't just sign it and then move on and forget about who they are.
Great. Okay, I think we have time for one more question here. We had an attendee asking for clarification around cross-device consent, right? So does it apply to companies' marketing websites versus their actual product? How do you kind of orchestrate all that? I know we can't kind of give specific guidance on specific setups, but is there any sort of broad rules for how to navigate the complexities of cross-device, cross-system consent, or anything along those lines? So if you have multiple websites, a login, or what have you.
Yeah, you want to think about, where is something getting connected? The whole idea of cross-device is there some identifier, some technological way that they're connecting person A across multiple devices. If there's no connection, and I'm Jodi on a corporate site and then I'm Jodi on a product site, and you barely know that I'm the same person, that's not the cross-device here. That's just Jodi in two places. If I am connected, the how I'm connected is the part that you'd want to understand a little bit further. How am I connected and what you're actually doing with that connection? Then you can start to address, is that going to be a cross-device thing? The most common is in the advertising and marketing space, where anyone here, if you've bought shoes or gone shopping on your mobile device, and then you go to a desktop device and it's following you, that is the most common cross-device activity. So I encourage all of you to go shopping and test it out.
Okay. Well, with that, I think we'll close the session. Thank you, everyone, for attending. Thank you, Jodi, as always, for joining us on all of our webinars. And thank you, Ashley, for lending us your expertise. We'll be sending out the slides in follow-up communications, and the recording of this will be available on demand and ungated on the Osano site in the near future. Have a good one, folks.
Thanks so much for joining.
Thanks, Jodi. Thanks all for joining.